order the meeting of the Oakland Planning Board. This is a special meeting for June 23rd, 2025. Pursuant to Chapter 231, Public Law 1975, Open Public Meetings Act, adequate notice of this meeting has been provided by adoption of an annual schedule of meetings, although this meeting was not on the annual schedule, it was a special meeting. We post a copy of same at Borough Hall and Borough's website. It's advertised in the record more than 48 hours in advance of the meeting, and we mail a copy to any person requesting the same. The meeting will conclude by 10:30 p.m., therefore no testimony will be taken after 10 p.m. Please rise for the flag salute. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Mr. Gisona?
Here.
Mr. Clark?
Here.
Ms. Levy? Mr. Morris-Cavetra?
Here.
Mr. Connolly? Mr. Kamen? Councilman Talamini?
Here.
Mr. List?
Here.
Mayor Kamala?
Here.
Chairman Potash?
Here. Mr. Gisona, you'll sit for Mr. Connolly this evening. And I'll entertain a motion to excuse the absences for Mr. Connolly and Mr. Heyman.
So moved.
Second.
All in favor?
Aye.
Okay. This time, Mr. Russo, if you could swear in our two
Yes.
board professionals.
Caroline and John, raise your right hand. Well, we know Caroline's going to make a presentation, but John, in the event that you're asked to answer some questions or give some testimony, the both of you state under oath that you're going to tell the truth and nothing but the truth, so help you God. Correct?
I do.
Okay, thank you. Thank you.
Thank you. At this time, I'll entertain a motion to open the meeting to the public for matters not on tonight's agenda.
So moved. Second.
All in favor?
Aye.
Is there anybody here who would like to comment or ask questions about anything not on tonight's agenda? Okay, seeing none, motion to close to the public.
So moved. Second.
All in favor?
Aye.
Okay, this evening, we have one item on tonight's agenda, and it's a public hearing for the housing element and fair share plan amendment to our master plan. And everybody on the board should have received a draft copy, and hopefully read through it. I know some of the members did, and asked a few questions and did a nice job at that. But anyway, our planner, Caroline Rader, is here, and she will go through the plan with us and give us an outline of the important items that we need to know.
Thank you, Mr. Chairman. Is this working? Can you hear me?
Yes.
Great. So Caroline Rader, the Borough Planner and the Board Planner with T&M Associates. So I wanted to start out tonight by just talking about why are we here? Why are we holding a special meeting? And not just a special meeting tonight of the Planning Board, I think you have your mayor and council afterwards, which I don't know how many other times Oakland has done this. I will tell you, this will be my first of 3 times this week that I'm doing double meetings and another night with just the Planning Board. So what's happening and why are we here? What we're here to talk about tonight is the housing element and fair share plan. That is part of the master plan. This board, the planning board, is tasked with adoption of the master plan, amendment of the master plan, etc. So that's why we're here tonight. That's why you're first, essentially. This board is considering the plan for adoption. So the master plan contains several elements, or essentially chapters or parts. Some are optional, a few are required. The housing element is one of the required components of your master plan. Now this is the housing element and fair share plan. So let's say two parts. So the housing element contains a lot of demographic information about your town, about Oakland, and a little bit about Bergen County. And the fair share plan contains information on affordable housing, on what is the borough's affordable housing obligation, and how is the borough addressing it. So I just want to speak a little bit about how we got to where we are tonight. So affordable housing in the state of New Jersey is a constitutional right. Municipalities have an obligation to provide for their fair share of the regional obligation. And that's an important component because, to remember, affordable housing is a regional obligation, and we talk about the region quite often. So when we're talking about your obligation, it is important to remember that absolutely nobody from the state or anywhere else came to Oakland and looked around and drove around and studied all of your plans and said, okay, Oakland's obligation should be X. And Wayne, which of course borders Oakland, should be Y. And Franklin Lake should be Z. And Demorest, which is elsewhere in Bergen County, should be A. And then A plus B plus C. It does not work that way. And affordable housing starts at the regional level. There is a regional obligation that is calculated. And we're in Region 1, which has the greatest of all of the different regional obligations of over 27,000 affordable units, which I believe the next region down has 20,000. So just to give you an idea of the difference. So what happens is, if you think about it like Thanksgiving, and you have a really big pie, and if you have a really big pie, you can have a bigger piece of pie because there's enough for everybody. It doesn't even need to be Thanksgiving. It can be any day when we're eating pie. And however, and that's how it works here. So we have a bigger regional obligation, so we have more to filter down to Oakland and to other towns within the region. So just sort of keep that in the back of your mind for starters. Now, affordable housing is handled in periods of years known as rounds. We are presently at the very end of round 3. Rounds 1 and 2, I believe, started in the 80s to 90s, and sometimes those are combined together and called prior round. Round 3, I guess, officially started in 1999, but we're going to talk about that in a minute. So there have been, over the years, case law known as the Mount Laurel decisions and the Mount Laurel Doctrine, which should sound familiar to everybody. The first Mount Laurel one was sometime in the, I believe, mid-70s. Mount Laurel 2 was what established COA, the New Jersey Council on Affordable Housing. COA, for many years, would calculate each municipality's affordable housing obligation, again, starting from the region, but each municipality's obligation. Municipalities would prepare housing elements and fair share plans and submit them to COA for a process of what was known as substantive certification. That was sort of your stamp of approval from COA, would be substantive certification. When COA went to adopt affordable housing rules in round 3, first of all, round 3 started in 1999. They were a little bit late with it. They adopted rules that had a principle in it known as growth share. Growth share was a linking of affordable housing obligation to employment growth and population growth. It was handled a different way, the affordable housing obligation. Those rules were overturned in the courts. Then COA went and adopted a second set of round 3 rules, also utilizing growth share a little bit differently. Those rules were overturned in the courts. COA went to adopt COA, the actual Council on Affordable Housing, went to adopt a third set of round 3 rules, and the council, which was short-staffed is the wrong word, short on appointments, I believe, actually had a 3-3 tie and failed to adopt the rules. Litigation ensued, and the round 3 process was removed from COA. It was declared moribund. It was removed from COA, and it was returned to the courts. So anybody who participated in the round 3 process with Oakland, and I know some of you are in this room, participated in a process where there was an action of declaratory judgment, where the borough reached settlement with Fair Share Housing Center, where the borough and Fair Share, together with what at the time was called a special master, which is now referred to as a special adjudicator, participated most likely in negotiations, mediation sessions, settlement hearings, etc. I personally was not involved in your round 3 plan, but was involved in others and have read your plan. So now, once after round 3, which again ends very soon in July, what happened last year was the legislature adopted legislation in March of 2024 that was signed by the governor. And now there was legislation that was addressing the affordable housing obligations and how they were to be met. For round 4, which it goes from 2025 to 2035, and all subsequent rounds. The legislation changed a number of things. First of all, it completely eliminated COA. Second of all, it directed DCA, the Department of Community Affairs, to prepare obligations for each municipality by a certain date, and those obligations were considered non-binding. It changed the way that bonus credits were handled changed the types of bonus credits that were available for credit to assist the town in reaching its obligation. It changed certain aspects of the vacant land adjustment. And one of the big things that I think it did, well, 2 big things, is one, it implemented very aggressive deadlines, which we're going to talk about in a minute. It also implemented what is called challenge periods. These are new, this is just a new aspect to the affordable housing process. So while I can tell you when the challenge period starts and ends, I don't have much to offer in terms of historical knowledge of what would be happening because this is new. And the challenge periods and the deadlines, they play together. They work together a little bit. So let's talk about some of the deadlines. So, and just as an aside, I did give a presentation to council about the legislation. Mayor, I feel like that was about at least a year ago. Maybe over the summer, I don't remember. So I did speak about a lot of this at that time. But regardless, the legislation was adopted in March of 2024. In October, sometime around the 18th of October of last year, DCA released its municipal obligations. The municipal obligations, again, come from the regional level and are filtered down through a series of factors, one of which was land capacity, i.e. how much land there is in a town for development. However, the mapping, I just want to point out that the mapping that went along with that analysis was not released until weeks later. So now we're into November. One of the deadlines from the legislation was that municipalities had to adopt a binding resolution by January 31st. That resolution needed to state what was the municipality's obligation, affordable housing obligation. They could either A, utilize the DCA non-binding obligation, or B, utilize a different obligation with an explanation of why that different obligation was utilized. All municipalities had until January 31st to adopt this resolution. Then there was the first challenge period, a 30-day challenge period, whereby any interested party could challenge the obligation that a municipality identified. And what ended up happening was that A, the Builders Association challenged each and every municipality that did not utilize the DCA non-binding obligation. I believe it was about 158 or 159 towns that were challenged, of which Oakland was one. In addition, the Fair Share Housing Center challenged, I believe, about 68 towns as well. Not Oakland, but they did have some challenges. What ended up happening after that, so that was the challenge period went through the end of February. However, pursuant to the legislation, all obligations had to be finalized by the end of March. So that gave basically 30 days for 100 some odd challenges. And what ended up happening is there's something created by the legislation known as the program. It consists of 7 retired judges who hear mediation and hear the cases as they come forward. So Oakland, like several other towns, participated in settlement hearings and mediation sessions with the Builders Association, and our special adjudicator also participated. In the end, Oakland settled on an obligation with the Builders Association, like many other towns did. So that was the first challenge period. And again, the legislation required that all the obligations had to be finalized by March 31st. And I will tell you, I was personally involved in a settlement hearing until 4:15 on March 31st. Not with Oakland, with another town. So these did go through the end of March. Now what is happening is, pursuant to the legislation, all municipalities need to adopt a housing element and fair share plan by June 30th, which is why we're having this special meeting tonight. Then it needs to be endorsed by the governing body, which is why mayor and council are having a special meeting afterwards. I will state that any municipality that does not adopt the housing element and fair share plan and upload it through eCourts to the program within 48 hours will no longer have immunity from exclusionary zoning litigation, which some of you may know by the more common term of builder's remedy lawsuits. Similarly, any town that didn't stipulate its obligation by January 31st also ran the same risk of losing its immunity. So these dates are important and aggressive. The reason that I'm sort of giving you all this background is I want to explain why we're here, what led to this, why we're doing what we're doing, why this board is considering this at a special meeting in the middle of a heat wave, because this is the deadline that was imposed by the legislation. We had an obligation that wasn't finalized till the end of March, and then we had till the end of June to prepare a plan. So that's why we're here now. I also want to stipulate that, again, from June 30th through the end of August, there is a 60-day challenge period during which any interested party can challenge a municipality's plan. And again, it's uncharted waters. I can't speak to what is going to happen or what might happen. Also, it is my understanding that the Fair Share Housing Center will be reviewing your plan, as will our the borough's special adjudicator. So a special adjudicator, which they used to be referred to as special masters, the court changed the name a little over a year ago. Those are professional planners, like myself, although I don't do this, who are appointed by the court to serve as special adjudicators, and they review plans, assist with mediation between the various parties, etc. So while we're adopting a plan tonight that I think is really good and meets all the requirements and the criteria, I want to put it out there that there is further review that will be happening. Everyone understand that with the background before I get into our plan? That's fine, Mr. Chairman.
Thank you, Carolyn. That's the best explanation I've heard on housing.
Okay. Okay. I think it's important to really lay the foundation and the background, because I want not only the board, but there are members of the public, and apparently this is being video. I have 2 cameras on me from different angles. I'm not sure what this is, who's going to be watching this, but somebody is going to be watching this somewhere. So I wanted to make sure that we were really clear with respect to the requirements and what the next steps are. Okay. So, as I indicated, affordable housing is handled in terms of rounds. For your round 3 plan, when you participated in the courts, there was your prior round, your rounds 1 and 2 obligations were combined with your round 3 obligation, and that was very That was a very common thing that happened. Sorry. Put my laptop to sleep. This board did adopt a housing element and fair share plan dated December 2022, but I believe it was actually adopted in early 2023, if my memory serves me correct. You have a settlement agreement with the Fair Share Housing Center, August 11th, 2020. You have a court-approved plan. So that's a very important thing to have, and we use a lot of the assumptions within your court-approved plan going forward. So it's a housing element and fair share plan. The housing element contains a lot of demographic information, which is very interesting to planners, but maybe not to most other people. For a few highlights, your 2020 census population was in excess of 12,700 people. Your median age of the borough was 43.8 years. You have over 4,300 households. That's an occupied housing unit, or a household is a group of individuals living together forming within one housing unit forming a household. And you have over 4,500 total housing units. You have an average household size of 2.87 people. Again, it's all very interesting, but I feel like we're probably here to talk about the Fair Share Plan, which is the affordable housing. So again, I had indicated DCA was tasked with developing non-binding affordable housing obligations. Affordable housing obligations are both present need and prospective need. Present need, I think, is a bit of an unfair term because it gives the impression that present need, that this is what Oakland must do right now today, June 2025, and that's inaccurate. Present need used to be referred to, it used to have several other names. So basically, it's your rehabilitation requirement. What that is number of units to be rehabilitated that are occupied by a household that is low or moderate income. So Oakland had a present need or a rehabilitation obligation under round 3. It continues to have one under round 4. Your round 4 rehabilitation obligation is 10 units. Oakland has established a municipal rehabilitation program. It is administered by CGP&H. They do a lot of this. And I think you've started rehabilitating a few units already, and you will continue with that program through round 4, and that's how we're addressing the round 4 obligation. The program is funded through the Affordable Housing Trust Fund. That fund is the funds that go into that account are from development fees and any type of payment in lieu. So that's that's your rehabilitation obligation. One other thing to note is that Bergen County has a home improvement program, and any resident of Oakland, just like anywhere else in the county, is eligible to participate in that program if they meet the income guidelines and the guidelines for the type of work to be done. So that's even though Oakland is required to and does have its own municipal rehabilitation program, there also is a county program. So I think what we're really here to talk about tonight is what is called officially the prospective need, but you all probably think of it as your affordable housing obligation. DCA calculated a prospective need obligation of 306 units for Oakland. A town, I will note, is in the Highlands, but 306 units. As was provided for under the Fair Housing Act 2, the legislation which is now the Fair Housing Act 2, we analyzed the data that was used to develop the 306 unit obligation, and we, the borough and its professionals together, calculated an obligation of 252 units. As I indicated, there was settlement and mediation, a lot of back and forth, and we settled at a number of 286 units. So that's our round 4 obligation. So we still in the plan have to talk about what have we done in the past, what are we doing for round 4. Round 3, as I indicated, which was done through the courts, your rounds 1, 2, and 3 obligations were combined. And those were looked at together, and it was 682 units. Excuse me. So, Oakland's vacant land is very limited because of environmental constraints, but even more so because, as we all know, you don't have sewer infrastructure, correct? Right? There's no sewers. So Oakland in round 3, which again covered rounds 1 through 3, had two things that were, its obligation was addressed in two ways: via settlement with Fair Share Housing and through a mediation process. One, there was something called a vacant land adjustment. That is a recognition that a municipality does not have enough land to build or to zone for its entire obligation of 682 units. There is a process that you go through to calculate not a new obligation, but what the borough aims to meet. It is known as a realistic development potential, or RDP, and your RDP was calculated at 148 units. I will note it is very important to remember that when you have a VLA and an RDP is calculated, the remainder of the obligation just doesn't go away. It's just looked at a little bit differently, in particular before round 4, and that's called unmet need, and the difference was 534 units. This was addressed through a variety of mechanisms identified in your plan, much of which was zoning for certain locations. There was one municipally sponsored site identified, bonus credits offered where available. However, you still don't have sewers. You go through this process, you still don't have sewers. There isn't any targeted date for sewers to be coming in. So you received what was called a durational adjustment, which is a deferral of the municipality's low and moderate income housing, your affordable housing obligation, based on the lack of infrastructure. There was a recognition in your round 3 plan. It actually correctly stated that the borough's durational adjustment would outlive the 3rd round, which again ends in the next few weeks, theoretically. So there was a recognition that you don't have your infrastructure, and it wasn't going to be coming by the end of round 3, 2025. In fact, it was recognized that that the durational adjustment would go into round 4, and that is what our plan so stipulates, is the recognition of the need for the durational adjustment and the right for the durational adjustment due to the lack of infrastructure. I'm going to take a quick break at this moment and mention, which I wish I had done at the beginning, that Oakland has been very proactive about this process. And the reason that I'm mentioning it now, we're going to see in a minute. And as I indicated in somewhat of a sidebar with the mayor earlier, I did give a presentation on the legislation maybe about a year ago. But we have been speaking, the borough's professionals and the borough staff and officials have been speaking about this, about the affordable housing obligation, about how to address it and how to handle it for several months, I believe. Myself, your engineer, mayor, the administrator, the borough hired special affordable housing counsel, as well as its borough attorney, and I believe at least one other person from the council was part of the committee as well. We've been meeting regularly, very regularly recently, and speaking. So I wanted to take this moment and sort of interrupt myself and indicate how proactive Oakland has been about this situation, because I think it's very important to say that there have been many meetings and many discussions and a lot of analysis of what is the best approach to take. I just wanted to say that. So now going back to your plan, your round 3 plan, again, durational adjustment, vacant land adjustment, you address it through a series of, as I indicated, inclusionary zoning, which means, let's talk about what is that, an inclusionary zoning, or subsequently what would be an inclusionary development, which are, you only have one that's under construction right now. The rest are not being built due to lack of sewers. But what inclusionary means is that exactly what it says, it's inclusionary. So there will be a certain number of total units, either in a development or before it gets to the development phase, permitted in a zone district with an affordable set aside. And what the set aside means is that a certain percentage of the total units need to be affordable. Typically it's 20%, sometimes also 15% is permitted for rentals. And I do believe you have one development under construction right now. Lennar, is that how it's known? Yes, Lennar, that is an inclusionary development. It's up by the school. So, number of inclusionary, so that inclusionary development as well as other inclusionary zones were utilized to meet the RDP. Then the unmet need was satisfied via establishment of zones as well. They were known as the DT1 and the DT2. There was overlay zoning put on those zones. And what an overlay zone is, and an overlay zoning can be done for unmet need, what an overlay zone is it can permit other uses besides the inclusionary residential development. So it's a zone district might be overlaid with another set of uses that are permitted, such as the inclusionary development that I referenced earlier. So that is the DT1 and the DT2 zones were adopted, and then there is there's an overlay option, an affordable housing overlay. So that's what that means. So going forward to round 4, as I indicated, continue to lack sewers as was anticipated. I believe the plan states something along the lines of no planned, anticipated, or estimated dates for installation of the infrastructure is known in the borough. There is also a recognition that that might change. Round 4 is a 10-year period. While there isn't a planned date, and it's not anticipated that at this time that there would be, were that to happen, the borough would receive advance notice. In other words, no one is showing up to install sewers on a Monday morning without people knowing about it for quite some time in advance. And the borough would have the opportunity to revisit its plan at that time to determine if the deferral or the durational adjustment, which is the deferral, still made sense. So the premise of the plan is the durational adjustment, the deferral of the obligation through round 4. There is one other item in the plan having to do with the overlay zone for the DT1 zone. There is a requirement within the rules about durational adjustments having to do with consideration of applications made to DEP for a town that has a durational adjustment. It's a specific section for which Oakland has respectfully requested a waiver from that section. And in support of that request, and to further articulate Oakland's commitment to provision of affordable housing in the manner that it is so able to do so, there is a recommendation to increase the density of the DT1 zone. So I'm just going to pull it up in my plan. So presently that zone permits a density of 18 units an acre. There's a recommendation to increase that to 22 units an acre out of support for this waiver request and to show Oakland's commitment to the provision of affordable housing. So I wanted to put that out there. That was what was in the plan. The rest of the plan has a lot of requirements addresses the requirements that are within the legislation, which is now the Fair Housing Act 2, dealing with consideration of multi-generational housing, other the state plan, and et cetera. Those are all requirements from the legislation. That is basically the plan in a nutshell. There are also several appendices. We'll go through those. The first one is actually, Appendix A is your rehabilitation manual, which exists today. Again, because you have a rehabilitation program right now, so it's going to continue. I would anticipate that manual, let me backtrack. With the legislation, there were certain other requirements, other types of affordable housing regulations that needed to be updated. Some of those are ongoing. Some, UHAC, Uniform Housing Affordability Controls, those rules were initially republished sometime in December with the, and they're probably going to be revisited, et cetera. So some of the affordable housing ordinances, et cetera, that we have today might need to be updated once these rules are finalized and once everyone's caught up to where they need to be. So I wouldn't surprise me if maybe there needs to be some tweaks to the rehabilitation manual, and I know CGP&H is very much on top of that. You'll note that your affordable housing ordinance and affirmative marketing plan are in an appendix, and I think I even have the comment that modifications are needed modifications will be made as needed to comply with any future round 4 requirements. The development fee ordinance, same thing. Now the development fee ordinance is what allows a municipality to collect development fees that go into the trust fund. And the trust fund is solely utilized for the provision of affordable housing. That's what is funding your rehabilitation program. That's what I believe you utilized perhaps when there was a property purchased several years ago for affordable housing, et cetera. There's within the trust fund, a certain percentage, 20% can be used for administrative costs, and then there are other requirements for other parts of the fund. You have a resolution within the appendix appointing the municipal housing liaison and your administrative agent. We have a draft ordinance, and then the spending plan, which is just a revisit of how the Affordable Housing Trust Fund dollars are spent. So that's a summary of the plan. Mr. Russo.
Yeah, I just, in reading the plan, I understood it to be that our prospective need is 286 units, correct?
Yes.
But you're gonna still try, under the durational adjustment theory, which is permitted by the code, to reduce that number.
I don't believe we can reduce it. No, it's a deferral of our obligation. The BLA, there was a BLA done under round 3 to 148.
So the 286 cannot be reduced?
If we come back and revisit our plan, then we can look at it, yes. It's a deferral of the obligation.
So would that be considered additional unmet need, where we now have 534 current?
I think that at this point, it's just deferred, and then we'd have to see what happens, if sewers come forward or, something else comes forward.
I'm just trying to run through the numbers to make sure I heard them correctly. I think we started off with a requirement under 1, 2, and 3 combined that you indicated was 680, with 148 being the realistic development, and 532 being deferred, and that was subject to the duration.
No,
Which-
I'm sorry, I think your numbers may be off a little bit. Can I repeat them?
Yes, please, that's why I'm trying to,
682.
okay?
Your RDP was 148 with the unmet need of 534. Does that not add up?
No, it does, I was off by 2. so-
Okay. Thank you. I know you looked at the plan pretty carefully, so I'm sure
Yeah.
you would have picked that up.
So I wanted to kind of connect the 682 to the 286. Are they similar, or is it the 148 to the 286? I'm trying to understand what these numbers mean.
So the obligations are cumulative. Is that your question? Affordable housing, let me rephrase that. The affordable housing obligation, that is not the rehabilitation, that's separate, is cumulative. So rounds 1, 2, 3, 4, you're gonna have 5, 6, 7 theoretically going forward, assuming there's no changes.
So the 682 is where we were at
And-
the end of round 3,
Yes.
and the the 286 is incremental.
It's added onto it, yes. I'm sorry, it's just very warm over here,
It's so warm, that's understandable.
and I'm doing so much talking. So, those are great questions, and it's complicated. I'm
Yeah.
not going to not, the whole, to be careful how I say this. The affordable housing process is complicated
Yep.
in New Jersey. It's not straightforward. So yes, those are great questions.
Can I,
And with a lot of acronyms also.
Yeah.
so at the end of round 3, we were at 682.
Yes,
Nothing has changed, and they've added 286.
yes. Well, originally they added 306,
Right,
which
right.
was brought down to,
But nothing has changed. So we settled in
we
round
settled
3,
for round 3, yes.
and now we're at round 4.
And next comes round 5.
Right, and so they're adding more to this, this arbitrary number. I'll call it arbitrary.
So you can say it however you'd like to, but yes, it is cumulative. Your obligations, except for the rehabilitation, which replaces, so your rehabilitation number replaces your prior rehabilitation number. But your obligation, your prospective need obligation, the big numbers are cumulative. Rounds 1 and 2, we're at round 4 now. So we have round 1, round 2, and round 3, and now we're at round 4.
But
Yes,
so
and then
if
in
I-
2035, you're going to have round 5, unless there are some unless
So
something
if I
changes.
have a 5-pound bag, I can only put 5 pounds of stuff in it, right? So next year, we've agreed that I have my 5-pound bag, and this is what fits in it. Now we're at round 4, and they're saying I have to put more of this stuff in my 5-pound bag.
It's an interesting perspective. I don't know that I've heard it relayed to in that manner, but okay, we'll go with that. Yes, it is and I keep saying this, it's
Yeah.
cumulative. This is,
So but my bag doesn't get bigger, but my requirement does.
your obligation, yes, your obligation gets, yes. I keep saying this, but
Yes,
I'm not
yeah,
trying
yeah.
to sound repetitive. Your
No, no.
obligation is cumulative. Round 1, round 2, round 3, round 4, and then round 5. So this is why I start with this very long introduction about why are we here? Why are we talking about these numbers? What has happened? And we have now moved from a process where COA has been eliminated completely. Not that it wasn't really doing much around 3, but it's been eliminated completely. And now we have new legislation. And the legislation again has these very quick-moving deadlines and significant obligations. I'm just going to go off track for 1 minute. So I started off by saying this was a regional obligation. We are in Region 1. Region 1 contains Bergen, Hudson, Passaic, and Sussex counties. Okay? So I want to, Region 1's total obligation, remember I talked about the pie, you have the big pie and you get a bigger piece of pie. Your Region 1's total obligation is 27,743 units. That's what was calculated. Any qualified urban aid municipality does not have an affordable housing obligation. They might have a rehabilitation obligation, but they don't have a prospective need obligation. So of that 27,743, that is then, as I indicated, filtered down, divided amongst all the other municipalities.
Can you give an example of the municipalities or cities that don't have to participate in this so the residents understand?
Well, it's not that they don't have to participate, they don't have a prospective need obligation. Sure. Just give me a second, please.
Lodi,
Lodi?
yeah, I did it, we did it last week, their rehabilitation is 144 to rehabilitate existing affordable housing units, and their future need is 0.
I'm looking on the list, I have a feeling what would be another one is, let's see, where's Bergen here? Oh, not that one. Actually, Bergenfield is, it's a qualified urban aid municipality. Cliffside Park,
Fairview, sure.
Garfield,
Garfield.
Hackensack, Lodi, Camden, Pensauken, Bridgeton in Cape May County, Belleville, Bloomfield, Vineland, Irvington.
So what differentiates them from us? Why we have the obligation, they don't?
Because they're what's called, are you asking what makes a town a qualified urban aid municipality?
How do they meet their number?
They don't have an obligation. So someone just say, how do they meet their number?
So in other words, they're built out already?
There's a list of urban aid municipalities produced by the Division of Local Government Services each year, relying, and I'm reading right from how the obligations are calculated, and relies on a statutory formula that considers the municipal tax rate, equalized valuation, number of children participating in TANF per, I don't know what that is, population and population density. The 2025 urban aid list, the most recent, was the one used for calculation. There's 62 municipalities. And then there's an analysis done if they're qualified. There's 3 tests looking at to see if they're qualified, having to deal with substandard housing units compared to all housing units in the municipality, if the same ratio was used, population density, and something else with population densities. So basically, all urban aid municipalities were looked at, and then they were determined, are they all what's called a qualified urban aid municipality. And then I believe, 47 of the 62 urban aid municipalities were determined to be a qualified urban aid municipality throughout this process. So they don't have, to whoever said it, they don't have a prospective need obligation. They'll have, quite often they may have a rehabilitation obligation that depends on each municipality. But so again, we're in this housing region 1. It has the largest and greatest obligation, and then it's filtered down. So did I tell you what was the next biggest obligation by region? Did I already do that? I did that, 20,000, thank you. Since you forgot what you said. And after that, after the 20,000, we go down 11,000, 13,000, 9,000, 1,800. I mean, so these are the regional obligations.
So just to be clear, you had stated that we have 4,300 housing units in town.
45.
45, okay? And our obligation is 968. So it's basically, the state's way of looking at this is you need to put 25% more affordable housing into our town.
So it's, except that the rounds are separated. I mean, the rounds are separated out, but
So
the
we're back
only
at
reason
bed.
the only reason that I'm bringing that up is because, and it doesn't apply to you, it applied to another town I work with. But the reason that I'm bringing this up is because if your obligation is a certain percentage of can't exceed a certain percentage of your occupied housing units, which yours doesn't, there's a cap on it for that, so you don't exceed that. I see, Mayor, what you're saying is you took rounds 1, 2, 3, and 4, you added them, you did simple math, you added them together, and you said this is our obligation. So right now you have the durational adjustment. You had it in round 3. It was anticipated to be extended through round 4. That's our case that we're making at this point in time. You had previously also a vacant land adjustment, which I'm assuming came out of settlement and negotiation and mediation as part of the court process. So this is the case that we're making at this point in time, with regard to the obligation. It is not unrecognized that the legislation is challenging, and there are elected officials, all I'll say is there are elected officials who participated in this process, so, that's what I can say about that. That is the legislation now, that unless it is changed, this is the process, this is the time frame, this is how it is going to be. So I will tell you, the plans need to be adopted by the end of June, 60-day challenge process, and then, 60-day challenge period. Then, after that, settlement and mediation, all of which is supposed to be resolved for every municipality by the end of the calendar year. So anyone who's doing the math recognizes that means September, October, November, December, everything has to be resolved. Any comments from your special adjudicator, Fair Share Housing, any challenges for every municipality. And I will remind you that for the obligations, there were 150 some odd towns that were challenged in the obligation, and that we had a month to settle, as well as the Fair Share Housing challenges. And we had a month to settle that, and it was hectic. So see what happens. Then once everything is finalized by the end of the year, then the towns have until sometime in March of 2026 to revise plans as needed, adopt ordinances, and do everything that is necessary to implement the plans as they are finalized. In my mind, the only thing that would bring a change to this time frame is if there is a change to the legislation, because right? Joe, are you? Because it used to be when there was COA, they could say, all right, there's a 6-month extension for all towns that are participating or something like that. But the only one who can make that change now is I believe the legislature.
Correct.
So.
And this is the same legislature that's forcing this on us.
Well, in fairness, Mayor, there's always been an affordable housing requirement, and they just adopted legislation that has this process in it, yes. And they changed a lot of other things as well, but anyways, that's what the legislation did. So, that's.
Joe, I'd just like to let's get focused on the job that we have to do, because, we can talk about these numbers and how unfair they are.
I agree with you.
It doesn't really, there's nothing this board can do about it. We have a job to do. And we had our obligation in rounds 1 through 3. We dealt with it with a plan, and the plan is approved. Now we've got to do the same thing with round 4. We have these 286 units that we have to deal with. And what Caroline is telling us is we're just going to continue our durational adjustment, because we don't have sewers. Now, the 148 units that we do have to, or that we could possibly provide, and John, you may be able to answer this, is that, would those 148 fall under the potential to put the sewer line in that's approved right now?
Yes, you
I'm saying?
received, I don't want to speak for Mr. I'm still butchering your name, I'm sorry.
That's
but,
okay, Yak is fine.
Yeah. But yes, there was a durational adjustment under round 3 for everything. There's and that's what we're continuing forward with round 4 is the durational adjustment. And there was a recognition of that. There also were analyses of flows and of gallonage that were contained within your settlement agreement, within your plan, and I did recreate one of the tables in the plan with the help of Mr. Boswell, because some of the numbers changed somewhat. Of this, the gallonage? Gallons per day, table 22, primarily came from your settlement agreement, but with some help from Mr. Boswell.
All right, so now part of the plan that you want us to approve also includes increasing the density in DT1 and DT2. And everyone
Just
on the board-
DT1, excuse me.
In DT1.
DT1.
Okay. which for everybody that doesn't know, that's our downtown, DT1 is our downtown area. So we have this overlay zone in DT1 that provides a certain density to put affordable housing units into. And now you're saying, okay, we want to show that we're trying to provide some of these units, we're going to increase that density.
Yes.
But does the sewer plan, would that allow for that? You know, is my question, right? You're increasing the density, the sewer plan is only allowing us to take a certain number of gallons per day, right? Now we want to increase the density.
It remains to be seen.
So we don't know, even under our current approved wastewater plan, whether we could handle those additional.
There are still many steps, water reallocation, et cetera. So it
So if we brought water in from
it remains
another
to be
area,
seen.
okay. So it is possible then.
Anything is
It is
possible.
possible.
Also, if you just want to point out, Mr. Chairman, there is a zoning map, greatly reduced in size, but it is one of your appendices. So if you wanted to, if you're able to see, it's that your DT1 actually falls quite nicely in the middle of the borough, if anyone wanted to just
It's
revisit
the
that.
majority of the downtown.
Yes,
right?
that's correct, Mr. Chairman, yes. But I
There's
just
a
wanted to
piece
point.
to the north that we call DT2, but.
Yes,
it's
Mr.
a
Chairman,
small
that's correct.
part, right.
Yes. And thank you for the reminder that while the numbers are challenging, there's a plan to be considered tonight, that the boroughs had discussions on for quite, well, boroughs had discussions on, for a while, and
So,
we've been
yeah, the
looking at this.
286, I mean, we may all think it's crazy, but that's what was settled, so we have to deal with that. And this, so that, you've presented a plan here for us to deal with that 286, and that's what we need to.
Thank you, and thank you for bringing us all back to that, Mr. Chairman. I appreciate it, because I know I get just as caught up in the numbers as anybody else.
Yeah.
I'm doing a lot of this these past few weeks.
Right, so.
But yes, I also, the attorney and I have discussed, just a couple of, do you want me to go into this now, or?
Sure.
A couple of quick revisions to the plan. Page 28, table 20. And I would like to thank one of the board members who did a very thorough review and pointed out this to me, that, so there are several columns in this table: project, block, lot, status, affordable units if there were bonuses, which really only applies to the bottom row, and the total. The West Oakland Ave 1 is shown as 6 affordable units, but that 6 was not correctly carried over to the total, where it shows 8. And 2 rows, and by the way, the West Oakland Ave 1 is what some people refer to as the Core-Mark. I think there's, we actually heard, I think the McDonald's, is it a McDonald's application recently?
Yeah.
That was part of the site and involved a subdivision as well as a site plan. The Terhune site, which is 2 rows down, similarly has 17 units in the affordable, but that number was not correctly carried over to the total. But it adds up, and I just wanted to point out that was a typographical error, and I really appreciate everybody's taking another look at this to assist with that. Similarly, there is a line on page 36 that just doesn't belong. It's the end of the third bullet, and do you want me to read the line, Joe? Or just,
Yeah, for the record.
the township's plan exceeds the 102 units required for rental housing. It clearly does not belong in Oakland's plan. And then there are a couple of, I'm sure as we go through this, there's typographical errors and things of that nature that are not substantive, so I just wanted to point those out.
Mr. List, did you have any other?
No, good.
Good.
Thank you.
Yeah, thank you for reading it through so carefully. Okay, do we have other questions? Mr. Collins, you have
Mr.
something
Russo.
down there?
I have questions, but I don't know if it's worth asking the questions because it's unrealistic, but it just
Okay?
baffles my brain. But The 900 units, do we have where we're gonna build 900 units? Do you have that on our master plan right now, where we're gonna build 900 units? Or do we only have where we're gonna build 248 units? Or 148?
The 148, because at this
That's
point, our
all-
plan involves a durational
So
adjustment.
that's, all we're shown is the 148, even though our number's 900.
Yes, because you received, yes, because some of it came out of negotiation under last round, but you have the durational adjustment, and that should be sufficient going forward at this point
And I
in
think
time.
most of it was the vacant land adjustment.
Right,
Yeah.
and that's, but
So-
the duration, yes.
But as the chairman said before, if we do put sewers downtown, we're just shooting ourselves in the foot. Because quite honestly, we're increasing the density of the downtown to meet this plan. Correct?
I'm not sure I'm understanding your
Well,
question, but I just want to
because
really
the-
make
I
sure
don't-
that we're all clear, excuse me, for the record, that this plan is that Oakland is creating a realistic opportunity within doing what it needs to do, and that there is nothing in here that is contradictory or trying to give the appearance of something that it isn't, or not trying, trying to make it appear as if
Oh, I
the
agree
plan is
with you.
unreasonable.
I agree with you, but we're increasing the density of the downtown, as the chairman just said, to meet this new number, to get to the,
You're increasing the density, yes, that is the recommendation within the plan.
that's the
As-
responsible thing. Where we're being told by our professionals, that's the responsible thing for this board to do to move Oakland in the right direction.
That's my recommendation, yes.
Okay, thank you.
And I believe it's realistic, yes. Thank you for your question. I'm hearing somebody talk, but I can't see who's talking.
Mr. Russo has
I just, Caroline, on the draft of the resolution that I prepared on page 3, the last bullet, where I said that although the borough's prospective need is present, that should be that although the borough's fourth round prospective need obligation is presently at 286, the borough will continue its efforts instead of to decrease, to defer that obligation, because
I'm trying to find, I'm sorry, I'm pulling it up as we speak, I'm sorry,
Because-
hold on.
And basically, I got that from, I think, in the report.
You think in the report?
No, I'm saying, what I just read, that was in my draft.
What page, I'm sorry, what page of the
Page
resolution are
3.
you on?
Page 3, the last bullet on page 3.
You think that came directly from the report?
No. I got some of it because in your conclusion,
Okay, okay.
Oakland lacks available infrastructure to provide for its affordable housing obligation, and therefore is eligible to continue its durational adjustment. So I sort of paraphrased it a little.
I think you did a good job.
But
Okay.
should the
Maybe
word
defer, maybe.
I think
the word
defer.
decrease should be deferred.
I think that might be a better option, if you're able, that would be, respectfully, that would be, I
Yeah,
think,
that's
my
what I think it should
recommendation.
be. So that paragraph should read that although the borough's fourth round prospective need obligation is presently at 286, the borough will continue its efforts to defer that obligation by continuing its durational adjustment pursuant to NJSC.
Thank you.
Okay, thank you.
Any board members wish to ask any questions of Caroline? Okay, seeing none, I will entertain a motion to open to the public for questions from the public.
So moved.
All in favor?
Aye.
Anybody here from the public wish to comment, ask questions regarding the affordable housing plan?
Same routine, name
Yeah, please state your name and address.
Steve Panosian, 69 Glen Gray. This is very complicated, but the question I have is more of a broader, higher level planning number or target number. If I understand it correctly, the state's number is 77,000. Is that correct?
I'm sorry, can you say that? The state's number is what? I didn't hear what you said.
I'm trying to understand where all these numbers come from, and it sounds like,
Question.
if I understand it correctly, that the state's number is 77,000 affordable housing units. Is that correct?
So our region is 27,743.
I'm talking
So
about
the
the whole
state,
state.
yeah, the state's over 80,000.
Oh, it's over 80,000.
Yeah, yes. I think I was kind of throwing some numbers out that were like roundabout. So I'll, here,
Yeah,
I'll-
I read, it doesn't matter what I read.
And this is just for round 4, correct?
yes, I'm only talking about round 4.
I'm not even there. The perspective that I got is the number that's driven by the state legislator, which is that total number of, you're saying it's about 80,000, I thought it was 77,000, immaterial.
Okay.
But what I'm trying to understand, it sounds like our region, which is responsible for 27,700 and change, is a part of that total number.
Yes.
Okay, so, and then Oakland, we have our number that's part of that 27.7, right?
Yes.
So what is driving our number going up? Does that mean somebody else's numbers are going down, or is that state number moving from 77,000 to 80,000 or higher? That something's driving the number up, this cumulative number that we keep referring to. Or am
I think maybe what you're missing is that 80,000 is not the cumulative number for the whole state. That's
That's
strictly a round 4 number.
For the next 10 years.
Okay, and out of that
For the-
80,000,
for the-
Oakland has 286.
But for the state though, the state
Yes.
has a number, and that number is 77 or 80,000.
Whatever, right.
Yes.
And that's only for this round.
Yeah.
There's other cumulative
Exactly.
numbers
That's-
before
That's
that.
where I'm going. What's changing to cause our number to go up?
That's what I thought so too.
The fact that the state is increasing the number, right? The
It's not
state,
because a neighboring municipality says, we can't do it, okay, who's gonna get,
So-
you take from them and give back? The reason, part of my question is, I was at a meeting in New York in White Plains last week. New York's number is roughly about 100,000 units, which I thought was interesting, the relationship between New York and New Jersey. Anyway, thank you. That helped me
Thank you.
understand it better.
So no other, just so you know, no other state does this like New Jersey. So whatever New York's number is, I have no idea what their analysis is or anything else. Yes, no, New Jersey is, solo like this.
Chopper Russo, 392 Rampo Valley Road. Great presentation. Thank you for the numbers. I know we're not going to have sewers or what have you, but going forward, can I just point to, like, say, a project that's being worked on now? It's from the old round. So if it was to come up now, the one on Courthouse, where we have retail underneath with 3 units on top, are we going to do like a percentage basis? Like, let's just say if that was 4 units on top, would one of those 4 have to be affordable?
So that's a great question. You do have what's called a mandatory set-aside ordinance. And that is a requirement, so that was one of your unmet need mechanisms, and almost every town in this area has one of those. You have to have a certain number of units in order to have that kick in, and I'm guessing that whatever was approved, this predates my time with the borough, I think it's 3 units. That's probably, it's 4 units there or 3 units there?
Board of Adjustment.
That was 3.
Yeah, that didn't come before us.
It did not qualify for
Right.
affordable housing.
But anything 4 above, I would assume would, correct?
So where you're,
I don't believe it was for.
No, it
Yeah.
wasn't.
But if it was-
I'm asking about the future.
So-
I'm from today. With what's going on with this, And I know there's a difference between you building new houses and having rentals. It's 15% versus 20%. Okay.
Sorry, we couldn't give you the exact, but it's in our ordinance.
it's in the
Those
ordinance,
numbers are.
section
I just wanna know
16.
where it gets activated. And obviously from round 2, or was it 3, you can't pay it away. It's gotta be done.
RCA, a regional contribution agreement, no, you're correct. I think those were eliminated in 2008 or somewhere around that time, when there were changes to the Fair Housing Act at that time.
Yeah, Franklin Lakes missed doing that. Okay.
Thank you. Anybody else from the public wish to ask a question? Name and address, please.
My name is Eric Schaubach, 61 Loyola Place in Oakland. I'm kind of surprised about all these numbers, and I probably might be stating the obvious that where are we going to put all these? And I also want to state something obvious. I'm the president of the Oakland Historical Society, and I want to make a point that the center of town has a lot of historic buildings that are worth preserving. And I'm wondering if there can be a provision in this plan for preserving those buildings. And especially in the DT1 and DT2, there are several buildings from the 1800s. I think they should be preserved, but I was just wondering if that can be put into the plan. Another point I wanted to make is not only do we lack the infrastructure for sewers, we also don't have the traffic infrastructure either. The town center is clogged with traffic already, and if we put 1,000 units, of course they're not all going to go in the downtown section, but that's going to really make a big difference in our roads. And I was just wondering if, as a question, does that have any impact on the plan? So those are my two questions, is are there provisions for historic preservation, preserving the character of our town? And also second, what about traffic?
So the traffic question is we'll call it the easier one. While there is a recognition of not having infrastructure for water or sewer being, handled in a certain manner, the Mount Laurel Doctrine does not, traffic is not an issue, school capability, things of that nature. No, the municipalities need to address that in their own manner. Many towns, I've been in a lot of these meetings this month, and many towns are saying the same things, you are. What about the traffic? Or where do the units go, et cetera? So regarding the historic nature of it, your DT1 zone exists today. I know we've done a streetscape ordinance to help with certain appearances. And I believe that I think that there might be some requirements within the existing ordinance and the appearances. That's not something necessarily for the plan, no, at this point.
So it's being kind of simultaneous but not related is what you're saying?
So,
concurrent, I mean.
well, there is a DT1 zone today, so, and I know that at least the master plan that was prepared, the master plan amendment that was prepared a couple of years ago does recognize the appearance and the developed characteristics of that area. So, I don't recall if the ordinance actually has anything in it or not. Like I said, the ordinance exists today, so.
And I think what Caroline's saying, this is like, it wouldn't be dealt with as part
In
of
here,
this.
this is not where we would look at something like
This
that,
is strictly
right?
affordable housing.
Mm-hmm.
You should read the DT1 ordinance, zoning ordinance, and then see what you think, because there is some language in there about character of buildings, et cetera. And then if you have other ideas, you should come back and talk to us.
All right, thank you very much, everybody.
Thank you. Okay,
Thank you,
anybody
Mr.
else?
Chairman. I was pulling up the DT ordinance as you were speaking, and there are criteria, there are references to the building's appearance, types of roofs, et cetera. That's all in the zone district, the zoning ordinance today.
Anybody else from the public with questions or comments?
I just got a real quick comment.
Just wait one.
Oh, sorry.
Get in line.
Hi, everybody, how are you? Susan Imperio, 71 West Oakland Avenue. I have a few questions. Number one, we were talking about how you're gonna either cross over into, land where it's not obligated or not quote unquote to be built on. Does that mean at some point, somewhere down the road, 10 years from now, something is gonna kick in where you're gonna start now implementing eminent domain to people and their properties?
Okay, so there's no eminent domain or redevelopment as part of this plan.
Okay.
I just want to say that.
I just want to
say that first of all, there's no redevelopment, or I'm going to say that again. There's no redevelopment proposed as part of this plan. Now, the second thing I'm going to say is, even if there were redevelopment proposed as part of this plan, or elsewhere, or not even part of this plan, redevelopment now does not necessarily need to contain condemnation, which is what you're calling eminent domain. A taking is what I believe you're referencing. So there is nowhere in this plan does it reference eminent domain, condemnation, or anything like that. As to what might the borough do in the future, I think that there's a lot of unknowns right now. Number one being the infrastructure, number two being what would the if the legislation is going to remain as it is, what would the numbers be, et cetera. There's a lot of unknowns, so I don't know that anyone, can speak for what might happen in the future, because a little over a year ago, none of us thought this legislation, none of us knew about this legislation, right? So I don't know that, at least I can't speak to hypotheticals of what might happen.
Okay. The other thing is that you mentioned something about 100 units in the West Oakland Avenue area. Where is that? Did you say something about, you mentioned
I don't
the
think it was
development
100
I did?
on
West
West
Oak-
Oakland Avenue?
The only thing that I know of on West Oakland Ave is right at the intersection with Rampart Valley Road. So you've got the Walgreens there, you've got
Right.
the City MD. So there's going to be a McDonald's restaurant and also a building, an apartment building that will contain affordable housing. I don't remember how big.
I thought it was 24 units.
Yeah,
If I said 100, I'm sorry.
Somebody said 100 about something, 101 or 100 that I caught. Unfortunately, I don't know if your mics are on or not, but we can, sitting over here, it's very hard to hear you guys.
Can you hear me okay?
I can hear.
Yeah, I'm the loud one. So,
I don't think
yes.
there's not 100 units on West Oakland.
My thing was the eminent domain, and the other thing was, the big issue with me is the water issue. Because I happen to have septic, and I've been having water issues, but I want to understand.
I'm sorry, I just was asking, you mean drainage. When you
For
say
drainage,
water, you don't mean
correct, for
drinking
drainage,
water. Okay.
Correct.
Okay. So, first of all, I appreciate what you're saying. And again, I know that there are issues in Oakland with that. So obviously, any type of, were there to be development in the future, it's just because something is in a plan that was approved under round 3 doesn't mean that once the sewers, should the sewers come in, that the next day there's a building permit in hand. There's still a site plan process whereby any development needs to come in for site plan approval before this board. It's reviewed by myself, it's reviewed by your borough engineer, who certainly is aware of your drainage issues and would be looking for, all stormwater management needs to be addressed, no runoff things, all those requirements aren't bypassed simply because it's an inclusionary development or an affordable development. There are other public meetings that take place to discuss any of these developments. I want to make sure that's clear too. They don't just get to go right to building permit. That's not how this process
Well, I
works.
understand that that's really not how it works, but it's, when you keep saying in the future is gonna be here before we know it. Correct?
Well,
There's a lot of things in plan, the future's gonna be here before we know it. So are we caught up to that future?
I think that we're doing the best we can to meet the deadlines and address the obligation in a responsible manner. If there is a specific water problem where you live or drainage issue where you live, right now, that's one issue that's separate and distinct from any affordable housing plan. If there is concerns about future development, like I said, there'd be stormwater management that would be part of any development that, affordable units or not.
Okay. All right, thank you so much.
You're welcome.
Thank you. Anybody else?
Just a quick comment.
Sure.
I still live at 69 Glen Gray. Steve.
Clarify.
And both worked at the Board of Education a couple weeks ago. So I looked it up. The number that Murphy signed into law is 84,698.
100, yep.
And I know that's not in our control, and it's defined, and I know this is Google, it's defined as a target number. I'm out of the corporate world, when I hear the number target, doesn't mean anything, it's still negotiable. But coming back to the fact that Governor Murphy signed this into law, and it's 84,698, this number could, it sounds like this number could only change if he or the next mayor, next governor changes the number. Would that be safe to assume?
So the number of the 84,000 unit
698.
number that, right. So what has happened is with that obligation, that's then broken up into the regions.
Right.
That's what I was trying to explain. And then it's broken into the regions.
Yep.
The only way, let me backtrack. That number is calculated a certain way, the totals are calculated a certain way based on the legislation.
Yep.
So that is how this is going to be addressed going forward, barring a change to the legislation, which is now the Fair Housing Act 2.
Okay.
Am I answering your question?
Yeah, I'm trying to understand the number, that number's 84,698 cannot change unless the governor.
That's the number right now for round 4.
But who can change that number? The governor? If the
that
governor
is-
signed it into law, it sounds like.
we need to have legislation, there would need to be a change to the legislation.
Okay, thank
And
you.
I think, I just want to also, I don't want to belabor this point by any stretch, but you were asking about the obligation and I just want to, without getting too granular, the way that the obligations were filtered down to each municipality was by looking at what was called factors. An income capacity factor, a land capacity factor, and an equalized non-residential valuation factor. Those 3 factors were a comparison of the town against the entire region, then the factors were averaged together and applied against the region's obligation, which is why the region's obligation is so important, because that's where it all stems from.
My question wasn't granular.
Though
My question was more higher level, you're granular.
I was trying to-
What I'm doing with this is 84,698 is the number. This is our number. Our number shouldn't change unless that top number changes or something else does.
Our round 4 number, I don't anticipate changing,
Okay.
but there will be a round 5 number.
Yep.
Hi, my name is Jerry Engermuller. I live at 24 Lakeview Terrace. I know there's some houses going in, so group homes for disabled people going in. So affordable housing, does that include houses for 55 and over and disabled or group homes? Would that be considered
Yes.
part of the housing?
So that's a great question, thank you. So yes, certain amounts of credits can be achieved via group homes or what's called supportive housing is like an umbrella term for, generally for certain demographic. Certain amount can be achieved that way, and you have in round 3. In addition, a certain amount can be achieved via age restricted or senior housing was the term that you used. And that actually, I believe your municipal project is going to be senior or age restricted housing. Yes, you're correct about that.
That would cover some of the obligations?
Some of it, but you can't cover all of it that way. 30%, age restricted housing is limited to 30% of your round 4 number. And then you also have to have at least half of your round 4 number available without restrictions, what's called available to families, et cetera. So a certain percentage, yes. And you have utilized both age-restricted and group homes in the past as well.
Okay.
Thank you. Thank you, that was a great point.
Anybody else? Okay, seeing none, motion to close to the public?
So moved.
Second.
All in favor?
Aye.
Okay. At this time, I will entertain a motion that we either adopt or reject our housing element and fair share plan amendment as prepared by T&M Associates. Would somebody like to make a motion?
Mr. Chairman, on the advice of our professionals, I think that quite honestly, we must move this motion, so I'm in favor of moving the motion.
Okay, there's a motion, we have a second?
Second.
Okay. Discussion. Mr. Russo?
Yes, with regard to the resolution that I prepared in advance of today's meeting, I just want to note that, as my discussion with Caroline a few minutes ago, on page 3, the last bullet is going to read that although the borough's 4th round prospective need, and instead of the word decrease, it will be deferred. And then on the last page, where the now therefore be resolved, and then be it further resolved, where we have the plan dated June 12, 2025. I'm putting an asterisk, and then I'm just putting down on the bottom that, and as revised to include Ms. Ryder's suggested revisions made at the hearing. Okay? So I want to make sure those were incorporated into the plan.
So, Mr. Russo, we're actually voting on your resolution.
Right.
Okay, so the resolution that you all have in front of you, okay, which refers to the plan, and Mr. Russo mentioned a couple of changes to that, and that's what we will be voting on. So when we vote on this, we'll be both adopting the plan and memorializing the resolution.
All at the same time. And it's basically, we're gonna adopt the draft of the housing element plan dated June 12, 2025 as a sub-element of the borough's master plan. And that we recommend that this plan be endorsed by the mayor and council of the borough of Oakland. And also, in some of our other resolutions, we give Caroline or T&M Associates discretion to make any minor revisions to the plan which may be required, necessary to satisfy the borough's affordable housing obligation. Okay? So,
Just one item of housekeeping, Mr. Gisone, I think I said you were sitting for Mr. Connolly, he since showed up, so you're now sitting for Mr. Hayman. Okay. Is there any more discussion before we vote?
we'll take Joe first.
Joe?
Question, the density is changing from 18 to 22. How
In the DT1 overlay zone.
does that have to be addressed? First question is that be addressed in this? Like,
Well,
that's
it's
part of
in-
it, or?
It's in the,
It's in the plan.
it's in Caroline's plan, okay, and this resolution refers to.
And then the second question is that 18, how was that originally calculated? Like, was that a result of other numbers, or was it just set?
So 18, that's, if I'm understanding your question, that's what's currently permitted. I'm assuming it came about via settlement and mediation under your round 3 process. I don't.
The density?
The density, yeah.
So it's just an arbitrary number, not based on
I'm
something else?
certain it wasn't arbitrary, respectfully. 18 is, that's not, we're in the realm of overlay zone type densities, and I'm assuming, but don't know for certain because I didn't participate, that it came about through your mediation sessions with your special adjudicator and the Fair Share Housing Center, but I don't know, I can't speak to what happened, I wasn't here.
Right, I mean, it's not, 18 is not a result of another calculation of something else that might have to change. That's kind of what I wanted to know.
I don't believe so, no.
Okay.
I think it's okay.
Is there any scenario where the town could be forced to put sewers in by the state or otherwise?
Not that I know of.
Yeah.
That's a legal question.
Yeah.
Say something.
Mr. Kemming just did.
Legal question she asked.
I know.
What the answer is.
Mr. Kemming beat me to it.
Mayor, do you have a?
Yeah, I just want to say, Carolyn, thank you for working through this. We spent numerous hours working on this, and unfortunately, we're dealing with a really ill-conceived piece of legislation coming out of Trenton and really rushing this through. This was only passed in March of '24, and here we are, a little more than a year and a half later, to try and make this obligation. We're not the only town working through this issue. This is statewide. And it's just the way that Trenton is just treating these municipalities is awful to make this number. It's just absolutely awful. But Carolyn, thank you, and thank you for everybody for all the hard work we did.
My pleasure.
It's a tough pill to swallow. Thank you.
My pleasure.
Anybody else?
I just wanted to add before the vote that, you're right, it was a team effort, and we did get the notices out, so just for the record, as I set forth in the resolution, the surrounding towns were served with the notice. A copy of the notice and a copy of the plan, as required, was sent to the Bergen County Planning Board and the New Jersey Office of Planning Advocacy, and the notice was published in the record. I have on June 13th, 2025. So all the notice requirements for this special meeting were satisfied. Just wanted to put that in the record.
Thank you, Mr. Russo. I actually did provide the secretary with
Yeah,
the white slips.
yeah, I got you white slips too. All right, we're good.
Okay. Roll call, please.
Mr. Gisonna?
Yes.
Mr. Clark?
Yes.
Ms. Levy? Yes. Mr. Marskovetra?
Yes.
Mr. Connolly?
Yes.
Councilman Talamini?
Yes.
Mr. List?
Yes.
Mayor Kamala?
Reluctantly, yes.
Chairman Potter?
Yes. Okay.
Thank you,
We
everybody.
have adopted, the planning board has adopted and memorialized the resolution. Okay. Okay, so we can skip over, review and discuss ordinance, there are none. Memorialization, we took care of that. We're not gonna pay bills, approve any minutes tonight. We're gonna skip over new and old business so that the mayor and council can do their meeting. Our next meeting will be on July 10th. We will have, looks like maybe 2 applications to hear. So I will entertain a motion to adjourn.
So moved.
All in favor?
Aye.
Meeting adjourned. Thank you, everybody, for coming.
Meeting called to order. This is the June 23rd, 2025 special meeting. It was a joint meeting. First, we had the planning board, and now this is the council portion of the meeting. Would the clerk please read the statement of compliance?
This is a special meeting of the Borough of Oakland. Notice of this meeting has been provided in accordance with the Open Public Meetings Act, NJSA 10:4-6 et sec, by notifying the Bergen Record, posting a copy on the bulletin board in the municipal building, and filing a copy with the borough clerk. Public notice of the time, date, and location was provided, and details for public access to this meeting were
Motion.
posted.
All rise for the Pledge of Allegiance. I pledge allegiance
To the flag
of the United States of America,
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Roll call.
Mayor Kamala.
Here.
Council President McCann.
Here?
Councilman Pignatelli. Councilwoman Rose. Here. Councilman Saliani.
Here.
Councilman Slasinski. Councilman Talamini.
Here.
Okay, do I have a motion to open to public?
So
Yeah,
Before we do that,
excuse-
Eric,
excuse.
I'd like to make a motion to dismiss Councilman Pignatelli and Councilman Slazinski.
Second.
Excuse, right.
Second by Talamini.
Excuse.
All in favor?
Excuse.
All right, motion to open to public?
I gave you your out, Carol. I gave you your out.
Motion to open to public.
So moved.
Second.
All in favor?
Aye.
Anybody from the public wish to address the governing body? Not seeing any, do I have a motion to close?
So moved. Second.
All in favor?
Aye.
All right, so before you, we have Resolution 25207. It is a resolution of the Mayor and Council of the Borough of Oakland endorsing the fourth round housing element fair share plan adopted by the Oakland Planning Board. All the members were present during the planning board presentation. They heard all the testimony from our professionals and also the debate from members of the planning board. At this time, I just want to say that as I indicated during the planning board portion of the meeting, we have a lot of our professionals worked very hard on this plan. Also, I just want to acknowledge the work that Council President McCann did working on this as well. When we came down to the deliberations and negotiating the number, it was days and hours working to get through this process. At this time, do I have a motion to approve 25207, resolution of the Mayor and Council of the Borough of Oakland endorsing the fourth housing element fair share plan adopted by the Oakland Planning Board?
I'll move it forward.
Saliani. Do I have a second?
Second.
Discussion.
Yes, I have a quick question. So even as we put this forward, it'll be reviewed by the state, and the state can still appeal back this motion, correct?
I'm sorry, can you please repeat your question?
With this resolution, With this resolution, the state has a chance to review it and come back, and they can challenge our resolution, correct?
They can challenge the plan. Any interested party
Yeah.
can challenge the plan. And you're correct in that, I don't know that the DCA is going to be reviewing our plan, but our special adjudicator will, and Fair Share Housing Center, which is a nonprofit housing advocacy group, will, also has the opportunity to review it. Mr. Gilson, is there anyone I'm missing? I don't believe DCA is actually going to be reviewing the plans.
I don't believe so either, but as you mentioned, any interested party, so any property owner in town would have the ability to challenge the plan as well.
Thank you.
You're welcome.
Any further discussion from the governing body? Questions for our professionals?
Mr. Mayor, I have a,
Mr. McKim, for Council President.
just a couple of comments. I want to thank our professionals. Caroline, you work really hard, not only working hard in Oakland, I know that your calendar is full of all the communities that you represent. I want to also thank Brian Giblin, our Council on Affordable Housing attorney. We probably should change that title. And I want to thank Mr. Gilson for all their hard work, and notwithstanding that my support for their appointments to work with us, I may have a different conclusion, that that's not a reflection on their hard work. There's something that came up during this process that was very disturbing to me. As you mentioned, my role was initially to help and advise, and as you noted, Mayor, I participated in the conferences with the judiciary, and what came to light during that time was in our discussions with the special adjudicator, he was being advised by a guy named Art Bernard. And Mr. Bernard, under the rules of ethics, and under the rules of ethics, the special adjudicator and any advisors are supposed to be neutral. And of course, if anyone can Google Mr. Art Bernard, I brought to the court's attention that Mr. Bernard was one of the architects and implementators of the original Mount Laurel plan going back to the late 80s. Mr. Bernard actually testified in front of, he actually spoke in public on behalf of a developer just 6 months earlier, prior to our meeting with the court. It was Mr. Giblin who pointed out the obvious, what he believed to be an obvious conflict of interest. Mr. Bernard and the adjudicator argued with me that that was not a conflict. Frankly, I don't know what basis they can argue that on. I'll let them stand on whatever arguments they made. They were nonsensical and circular arguments. But ultimately, Mr. Bernard was removed or stepped down. I believe he stepped down. I want to be correct on that. Actually, I'm not clear. It was never clear how he was no longer. And we had another meeting in which we moved down from the, was it 306 or 309?
Originally, it was 306.
306.
And just to clarify, Mr. Bernard, I do believe stepped aside.
He stepped aside?
I do believe that.
Okay. He didn't want to, that was for sure.
Well, I know.
And in fact, the adjudicator didn't believe he needed to. But he ultimately did. But he didn't step down from that process in other jurisdictions. He still participated throughout the state through the similar process that other towns were going through, that we were going through. And I find that very disturbing. I find it disturbing that the judiciary did not remove him. He's not, in my opinion, he was not an unbiased advisor in these discussions. He also informed us, for the first time that I heard, and I had read the legislation, that the DCA had concluded that as we met our local need, that whatever we subtracted in our negotiations had to be picked up in the regional need by another community. And that it was the DCA's position and the Builders Association's position that when we calculated our need with our professionals, that we should have included in our calculations the regional need. So we should include in our calculations Patterson, Paramus, anywhere else. And I asked the question, well, why wasn't that done by, because you would think the DCA would do that. And the answer was because they didn't have the ability to do that. So I would question the process here, because if DCA, a state agency, who is responsible for interpretation of the law, where for the first time in a settlement discussion, we are learning that the DCA's interpretation of this statute is that we're supposed to calculate the regional need. So if we want to take 50 units off, we have to find where those 50 units are going to go in another community. And that's the interpretation endorsed by Mr. Bernard to the special adjudicator. I find the process messed up. I also, it's just, on its face, unfair. Minimally, at a minimum, it's unfair. And it tells me that there was a question earlier tonight put to the planning board, and it was a good one. You know, what's to say down the road the state cannot say, now you have to have, we're going to pass a law, and now you have to have sewers. And then the question, well, who pays for that? Are you going to tell the mayor and council you have to put in sewers, and you're going to have to raise everyone's taxes $500 a year on the average house? It's a lot of money. And it also creates a lot of dissent. It creates a lot of hostility amongst neighbors against the local elected officials when the state mandates something like that. I thought her question was right on point. Where else is this going? And I would ask this question of the DCA. Why have a running count from round one to round two to round, what else, what is the purpose of having a running count? There's only one purpose that I can think of. So this election, it's not about Republican and Democrat. This election is, where do you live? And what kind of community do you want to live in? The idea that you would take out of the calculation traffic, the impact of traffic, is nonsensical. And it tells you there's another agenda. Mr. Saliani and I, if you didn't notice, we were chatting over there, and he brought to my attention, you know, our need is I think we settled, again, 286.
286.
That's, in terms of numbers of units built, that's times 5. 286 is the number, and we're going to reduce that through another process that we have coming up. But whatever that number is, in terms of what needs to be built, it isn't 286. Say we settle at 200. It's 200 units times 5. There's smarter people in the room that can do the math faster than me, even with that round number. So my concern isn't what our professionals have recommended under the limited scope. They're charged with, this is the law. I thought Carolyn did a really good job of answering the questions about hypotheticals, because it's really not before her. She can only answer the questions that are put before her as it relates to what needs to be done tonight. I thought Mr. Yukemic's legal answer, although he's not an attorney, I thought maybe the attorney was a little slow on the legal question from the board member. You know, where is this going? I don't see any reason to keep accumulating our prior needs, because it leads to only, as potentially pointed out, where, you know, eminent domain is a local, under our state government, under our constitution, is a local authority. But, you know, state constitutions change, DCA members change, legislators change. So we have to ask ourselves, in the future, as was pointed out by the person asking the question, where are we going? So we have an imminent need and an imminent responsibility to address tonight and vote on, as pointed out by the recommendation of our professionals, and they believe it is it's responsible to vote yes. So, but I also have an Esquire at the end of my name, and I'm entitled to my opinion as well. So I just wanted to put that on the record, Mayor.
Thank you.
You're welcome.
Anybody else? Carol Ann, Russ? I just want to make one other comment. I had asked our borough attorney prior to this meeting, when they passed this law in March of 2024, and I was asking what the breakdown of the party and the party line vote went on this thing. And Mr. Gilson, could you tell us what your finding was?
It was a strictly party line vote. There were no Republicans in favor of the legislation.
So, I just,
And all three of our legislators voted against it.
I just want to put that on the record so that people watching this understand where this is coming from and why this is happening. Is there any further discussion?
I would just like to add one more thing. I don't care what party you belong to. This is about where we live and why we moved here, why people who moved here, third generation here, you know. The question was asked with regard to the zoning from the historical president about the character of the town. I mean, I think that is, again, I'm just looking at it from a different perspective. I'm looking beyond what's in front of us right now. I think that the idea that if we were to ultimately have 200 units, that we would have to build times 5, I think undoubtedly, and not take into account the effects on the school and traffic, which is, of course, the only things you should be looking at, exclusively, right? That's really, what else, what other questions are there to ask? Can we handle the flow? Can the town bear it? To the characteristics, that's our sense of community. We all live here because we love where we live. We could fight about politics. You could talk about Biden and Trump all you want. But at the end of the day, we all live here. We all go to the ShopRite. Well, most of us. Okay. I've seen some of our Oakland members, our Oakland community at the ShopRite in Wyckoff for whatever reason. But we all live here. So Mayor, I think that's good that you point that out, but I just think that this, for me, this comes down to the community as a whole.
I agree, Council President.
Thank you.
Any further discussion? Not seeing anything? Roll call.
I need a motion
Oh.
to,
We had a motion.
We already did it.
Motion on the table.
Motion on the table is discussion.
I didn't hear who motioned in the first place, that's why.
Oh, she didn't hear it.
So who
I
did
was the original motion.
Steve?
Steve? Sorry, I didn't hear anybody motion.
I think you need to close the discussion, right?
Okay,
And we voted on closing. Did we vote on closing?
now we got to move to
discussion?
close, motion to close discussion.
So moved.
Do you have a second?
Second.
All in favor?
Aye.
Okay, so now we're gonna vote on the,
Now we're going to vote on Resolution 25-207, resolution of the Mayor and Council of the Borough of Oakland endorsing the fourth round housing element and fair share plan adopted by the Oakland Planning Board. Roll call.
don't we need a motion?
No, we already,
We did a motion to open, we
No.
did a motion to close, public. Don't we need a motion, Matt,
I believe we had a motion on the table for,
Discussion.
for discussion?
but we did have a,
we had a motion.
To
We made a
open
mo-
up-
but the way the resolution works, I mean, we can just re-motion, but a resolution, it's not like an ordinance hearing. Once we motion and second, then there's
Okay,
a
so then
a discussion
Sally, Annie, and
amongst
then
the
Russ with
council.
the motions
Yes.
in the
Right.
first place. Okay, I just want to make sure we're all clear. Okay.
Good.
Councilwoman Rose? Yes. Councilman Saliani?
Yes.
Councilman Talamini?
Yes.
Council President McCann?
No.
Motion passed.
Okay, the motion passes. Not seeing any further business on this agenda, we'll have a motion to adjourn.
So moved.
So moved.
Second. All in favor?
Aye.
All right, the next Borough Council meeting will be held Tuesday, July 15th, 2025, 7 p.m. in the Borough of Oakland Municipal Court, Council Chambers, 10 Lawland Drive, Oakland, New Jersey. This meeting is now adjourned.
Thank you.
Thank you, everybody.